Hey guys, welcome back. Joe Brunsman, insurance broker to the stars here. So a topic of great contention as I've seen it, both with my own clients or MSPs and MSPs out on the interwebs, and that's whether MSPs should be filling out their clients' cyber insurance application. The moral of the story here is pick your poison. All right, so the short answer is no. We could say, all right, that's the end of the video, but of course there's always more to the story and there are more considerations you should have as MSP ownership. Now, the three main approaches I see are: one, MSPs outright refusing to even touch the application; two, only answering the technical questions over the phone; and then the third is going to be answering the technical questions on the application effectively, whether it's PDF or whatever, using their own pen, so to speak. All right, so let's talk about outright refusal. So one, from what I've been able to gather, this is the least common approach, and it appears to be very unpopular with clients, and I could see why, right? So your client's saying, hey, there are these very technical IT questions, you're my IT guy, and so I'm not really sure how to fill this out. I feel like I'm going to screw this up. You're the subject matter expert. Why aren't you helping me here? So long term, I'm not really sure how feasible that's going to be. And I would also say that we have to start thinking about what are the odds that your client screws up that application. I think if you just put something in the hands of the end user with no technical knowledge, the probability that they're going to screw that application up are really quite high, unless they have maybe in-house IT, but only then, they may have part of the picture, but probably not the whole picture. All right, next, the phone method. What are the pros and the cons? Phone method, at least a perception of least liability there, because the MSP's idea is they could say, hey, if you get your coverage denied, we didn't even touch that thing, that's all on you. All right, now the cons to that, I would say the client is very likely to misinterpret the answers you're going to give them, right? Like imagine just troubleshooting over the phone and trying to talk them through something that's very complex. You guys know how that goes. Generally doesn't end well. That's why you can go in, take over their computers, and move from there. All right. So I would say you have to be careful here, because I think the probability that they're going to misinterpret what you tell them or allege they misinterpreted what you told them are really quite high. And of course, this could also annoy the client. And with all of this, I would say it's probably a likely likelihood of coverage denial on their end if you're just answering something over the phone, because yes, they could misinterpret your answers, but you could also misinterpret the question, right? Like there are plenty of applications. I'm an insurance broker. I do this all day, every day, but I still have to read over those questions and see them on a page a few times before I can really start to understand what it is they're getting at, right? Sometimes the grammar's terrible, the syntax is all over the place. So just going over the phone, I don't think that's as safe as MSPs believe it to be. All right, now let's talk about the pen method. All right, the pros here: you control the answers. Nothing is going to be lost in translation between you and the client and your client and the insurance company. I would argue that using the pen method is likely the lower risk option, all things considered, right? Now, the con here is there is a perception of greater liability because you've actually put your pen to the page. But if you're going to do this, you have to know how the game is played. All right. And I'm here to help you with some of those ideas. So first off, let's talk about liability. What is negligence, right? If you're going to face a claim, this is a common cause of action that we're going to see against MSPs. It's plaintiffs are going to say, hey, my MSP was negligent. All right, now generally, I just pulled this out. A party fails to exercise the due care that a reasonably prudent person would have used under similar circumstances. All right, there we go. Depends on the facts of the case. But we have to think about long term here. If we start looking, kind of like a few steps down the line when a cyber claim is denied, right? What's your client going to say? Hey, my MSP didn't fill it out, but you know what? I still got hit. I still think you were negligent. Maybe they'll allege, hey, you didn't even help me out. You're the subject matter expert. There's other MSPs. Maybe my expert witness gets up there on the stand and says, well, Yeah, we're an MSP and we always help our clients fill out their cyber applications. So we think that the MSP was also negligent in not helping fill out the cyber application, right? So you're going to have to contend with that. And then the phone method, all right? I think that my MSP said X, so they were negligent in their answers and for allowing the cyber event to occur. All right, so did you actually say X, whatever the answer to that question was? Who knows, but now you have no paper trail and it's he said, she said, and you're still in the same boat. All right, or the PIN method, hey, my MSP put X on my application, so they were negligent in their answer and for allowing the cyber event to occur. All right, so I think either way here, the reason I called this presentation Pick Your Poison is because no matter what, I don't really see a feasible way that you can actually remove potential liability there. All right, so in total, I would say, I think the liability is inescapable. Ultimately, what it comes down to in my mind is control, right? How much control do you want to have over the process for something that's highly technical where your clients have hired you because they are not technical people and they don't even want to understand this stuff. All right, so in that realm, let's look at what could the potential coverage be for you if a claim comes against you dealing with this application. All right, I would say, one, I think that this falls under consulting, right? But you have to look at your own policy. If you're ever in doubt, talk to legal counsel first, right? I'm not your insurance guy. So you'll see here, great definition. Technology services means IT services performed by and insured for others, including but not limited to computer consulting. You are consulting with your client on the answers to those questions, right? And even a worse definition, this one is from Hartford, I believe, right? Arguably worse. Technology services means, so it's not including but not limited to, it's a named peril, not a better all risk policy, but it still says perform for others for a fee or remuneration, consulting, analysis, etc. All right. So I would argue that if a claim popped up because of what you said or what you did on that application, then it would arguably be covered under computer consulting. Moving on here. So what actually leads to trouble? And I see a lot of, I'll just say misconceptions around what is actually a problem when it comes to cyber insurance. Now, one, we have to understand that declinations of coverage are actually still comparatively uncommon. I have actually never had, ultimately, a declination of coverage. I've had a few where the insurance company tried to, but the claims guy was wrong and I was able to prove that and they had coverage. All right, so cyber claims are still relatively uncommon at the end of the day. Don't look at like the huge headlines, the $100 million policies. That's how the game is played at that level. I'm talking about the SMB and large business space even, not like the huge multinational, multi-billion-dollar corporations. That's a different idea. So right here, I actually just made a previous video, how to lose $1 million with your cyber application. This was Travelers versus ICS. I will actually link to that above right here. But the moral of the story was you had this MFA MFA attestation. All right. If we go down here to question number 3, right, you're going to see in addition to remote access, MFA is required for the following, including such access provided to third-party service providers. So you would have to jump in on this question arguably anyways if your client's filling this out. But you'll see here, words have meaning. What does the word etc. mean? We have no idea. Now, in this case, it was pretty blatant. This is actually from their application. It was pretty blatant. It looked like from the allegations made by Travelers that they didn't have any of this stuff. He just marked yes so they could get their cyber insurance, come back, and they had their claim denied, right? And policy rescinded. So what actually brings trouble in an application, right? If we're going to bring technical terms to what I just showed you, in an insurance contract, a material misrepresentation occurs when the insured makes an untrue statement that, one, is material to the acceptance of the risk, would have changed the rate, how much the insurance company would have charged you if they knew what the correct answer was, and then the remedy to that is rescission. All right, now, depending upon the state in which the dispute is brought around if it was a material misrepresentation or not, there's a bunch of rules. Kind of the general idea is like you actually had to know that you were lying about something, right? It wasn't, hey, this is our best faith guess on what that question meant, so we answered it this way. No, it has to be something that's like really blatant. And keep that in mind because juries hate insurance companies. All right. So when a claim gets denied, something that an insured has in their bat belt there is something called a bad faith claim. If they think the insurance company was acting in bad faith, right? Like the insurance company goes, we're just not going to cover this because it's a big claim and we just don't want to pay. So we'll deny coverage. Juries do not look favorably upon bad faith claims. All right. They hammer insurance companies if you have any ground to stand on there. All right. So more of the story here is just don't make a material misrepresentation. This is all from the Journal of Insurance Regulation. If you're a nerd like me and you want to look it up. So what are some of those application best practices, right? Let's say, I'm not telling you what to do here, but I'm saying, at least in my mind, it comes down to control. And I think the best control that you could have as an MSP is actually getting a hold of that application and answering the technical questions. Now, in that vein, please don't answer stupid questions, right? We saw one of those before, like the etc., right? Don't answer that. It's impossible to answer that correctly, at least in my mind. And only assist with the part that applies to you. All right, there's going to be multiple areas of that application. Only part of that is going to apply to you, all right, and your client. So applications, remember, they're everyone's problem. So all parts of their organization is going to be involved with this. So we're looking at technical, administrative, and physical safeguards. Now, you probably have a pretty good handle on all or most of the technical safeguards, right? I would say most if it's like a co-managed situation. But the administrative controls and the physical safeguards, that's just not your area. So I would say you probably shouldn't be diving into that. Next, it's okay that you just don't have all the answers there, right? Just stick to the part that applies to you if that's the route you pick. And make sure that you're diligent about how you answer those questions. Next, definitive questions and definitive answers, right? Keep in mind, insurance policies, these are legal contracts, all right? So if they're requiring definitive answers, you have to make sure you can provide that, some of which may be impossible, right? So for example, are you HIPAA compliant? I don't really know what that means. I've got a master's in cyber law. I'm not really sure what it means to be HIPAA compliant. It's in my book. I've read through all of HIPAA High Tech, and I've read through tons of HHS OCR actions against organizations, but I'm not really sure what it means to be compliant. All right. So maybe you have like HIPAA Shield or something like that. So instead of answering yes or no, you just put in an addendum. You're like, we have a HIPAA Shield compliance certification, right? So you kind of split the difference there, right? Something that's impossible to answer. Are you compliant with all applicable state and federal cybersecurity and privacy laws? I'm not sure how anybody could truthfully answer that. I would say you could probably answer it in good faith and be like, well, yeah, we think so. But there might be some law out there you don't even know exists. All right. So be careful on how you answer that. Next, make the broker, that's me, and the underwriters actually think and do their jobs. All right. The insurance industry is too much of just shuffling papers back and forth and making money, when arguably we are supposed to be adding ultimate value to the client. All right. So you can always add an addendum. All right. If something is a sorta, a kinda, a maybe, I'll give you an example. Is MFA required for email access? All right. And there's the 85-year-old bookkeeper that just doesn't own a cell phone, can't be bothered to use MFA, doesn't have some alternative method. Here, you can't answer yes. You don't want to answer no, so add an addendum, right? You could put down everybody except the bookkeeper, right? And then arguably, I would say go back to the client and be like, hey, we need to revisit this because that's a pretty risky way of conducting your business. All right. If you don't understand what something means, just ask them to define their terms. It's very simple. All right. I actually do that all the time, right? I'll call up underwriters and I'll go, what do you mean when you say X, right? And that underwriter should have additional training. It's their application. It's their insurance company. They should have additional training and insight into what they're actually getting at there, right? Next, keep in mind, most brokers don't actually know what they're selling, nor do they necessarily have any legal liability to understand what they're selling. So just brace yourself for that. Don't get too frustrated. All right. Generally, how it's going to go is question, client, broker, underwriter, and then back. All right. So make sure you're giving yourself plenty of time here. Next, think liability, you and them. All right. So it should go without saying, but your job is not to make your client look good. That's going to get you in trouble. All right. 100%. That's going to get you in trouble. All right. So just be 100% forthright with your answers. And you may not have all the answers, all right? It doesn't make you look dumb. It doesn't make you look stupid. You're the subject matter expert, right? If something just doesn't make sense to you on an insurance application, just ask, all right? Remember, these applications are generally written by attorneys, not written by tech folks, all right? If they were written by tech folks, it'd probably be a lot easier to answer, but such is the game of insurance, all right? Keep in mind you have all those different application sections, so just stick to what you're doing. All right, and go deeper. Use the application as an opportunity. You can talk about controls, processes and procedures, regulations, compliance, etc. All right, I think cyber insurance applications are a great time to talk to your clients about increasing their security. I do it over here, and I don't even get paid if they implement some new additional control, or suddenly they're like, hey, EDR is a great idea, or whatever that control would be. I think you should use this potential pain in the butt as an actual opportunity, right? So flip the script on that. So at the end of the day, you got to pick your poison, all right? You have to pick your poison. It's going to be one or the other, but at least in my mind, I see no feasible way to remove yourself from some type of liability. So I think ultimately it comes down to control. All right. So be 100% forthright on that application. If you are going to put pen to paper, make sure you know how to play the game. Consider adding those addendums to add clarification to the answers. All right. Don't answer stupid and impossible questions. And when in doubt, make sure you seek legal counsel to assist you. All right. So if you guys found this useful, you learned something today, like, share, comment, subscribe. Right above me is another video that the YouTube algorithm will recommend to you. And if you click over there on my beautiful face, you can subscribe to my channel. All right, guys, with that, stay safe.